Hello, hello, hello. Hello? Can you hear me? Is this, yes, I can hear myself, so you must be able to hear me. Hello, and welcome. My name is, like so, is that better? Huh? Technical people. All right, my name is Audun Løvli. It's spelled out in the program if you wonder how. I'm a PhD student at the Center for Discretion and Paternalism, research on discretion and paternalism, and I'm moderating this panel on international rights and cultural practices. It is framed by the issue and questions concerning underage marriage. Statistics from UNICEF this year in March that I found tells me that 21% of young women or girls are married before their 18th birthday. And, whereas 4% of young men or boys are. The United Nations Convention on the Rights of the Child places extensive obligations on the governments to protect the rights of children, yet large differences in how the UNCRC is interpreted and implemented remain. This is a fundamental violation of human rights, yet despite laws on the matter, the practice remains quite widespread, partly because of inadequate or impotent legislation, a lacking or limited infrastructure to register marriage and enforce compliance with legislation. In recent years, the European context for the understanding of female children's rights has been challenged by the influx of migrants, particularly when and where these are children that are married to adults. Some of these married migrant girls are in their early teens. They may have children, and they are in a sexual relationship with an older man. The reasons for child marriage can be found in cultural tradition, family honor, protection, you may call it, social norms, customary and or religious laws that condone the practice, poverty, and of course, gender equality. But after migrating to a new country, these reasons become questioned. Child marriage is a harmful practice in several ways. For instance, it increases the risk for domestic abuse and violence. You may be sold into prostitution and slavery as part of a trafficking sort of scheme. There is rape and, of course, childbirth complications. In addition, child marriage tends to keep the child from entering education or completing school if there wasn't a sort of initial entering into school. And this results in social isolation. It limits their career and vocational opportunities, and too often entraps them in poverty. So I have a panel of 5 scholars, and I asked them to prepare presentations for about 7, now 8, 9 minutes. If they've received a bit more time because someone had to pull out in the last minute. So I gave them 2 guidelines. I wanted them to prepare a presentation on the status and experience with child marriage in the country that they come from and seen through the practice of their field. And then a second sort of ambitious guideline is how can this inform the overarching question of the session, which is spelled out in the program, and I can repeat here, which is what should, and I've added, what can the state do to protect these children? So I hope this discussion will shed some light on the situation and sort of what is being done and what can be done. And before I let the panel loose and introduce them, I will ask you that you wait with the question until the end, like the previous and the panel before that, so we can sort of sum it all up. And then, without further ado, I will name the panelists, and that is Satang Nabane from the University of Pretoria, and also, as I understand it, connected to CMI. There is Jana Kothari from the Center of Law and Policy Research in India. There's June Thoburn from University of East Anglia, UK. Kenneth Burns from the University of University College of Cork, Ireland, and Thomas Mason from SOCLIS, International Center for Social Legal Studies, Heidelberg, Germany. And Kenneth will start this. This is yours.
Okay, good morning. Is it on? Yeah. Okay, good morning. My name is Kenneth Burns. I'm a college lecturer in social work in the University College Cork. I also have a second title, that's an honorary title. I am the Special Rapporteur for my 11-year-old daughter, who is especially interested in this topic. So, why are you going abroad? Who will you be talking to, and what will you be talking about? She rightly pointed out my lack of expertise in this topic. So I would like to lower your expectations in that actually I knew very little about this topic, but it's been a great opportunity to think about it. So as a social scientist who was highly trained in research methodologies and who knew they had to do a piece of research, I did what any good scientist would do. I made a phone call to my mother. And as you all know, parents are a huge reservoir of social history. And I erroneously thought that Ireland in its history probably, I'm thinking now like 100 years, my mother is 75, so she would know about her parents and her grandparents, so I'll be stretching back to the end of the 19th century. And I asked her, and she said, what most mothers would do, would you like me to ring all your cousins and uncles to find out? And what I established from conversations with her was that in her friends, in her extended family, in her families going back generations, that child marriage wasn't a thing. And that in fact, women and particularly men in Ireland were older when they got married. So this is the marriage cert for my grandparents. I knew that they got married, so it's 1914, but they didn't get married young. So that led me to think, okay, well, what was happening around that time? So this is the statistics from 1921 to 1931. And you can see in the column that's marked, persons not of full age, which means under 21. You see that for men, you have 1.37 marriages per 100, and for women, you have 6.1 marriages per 100, and that increases slightly up to 1931. For those of you with a keen interest in history, and for those of you with good eyesight, you might note the last sentence on the screen, which makes it very clear that Ireland's child marriage rates were significantly lower than Great Britain's. So we have a relationship with the United Kingdom. And that continues to the year of my birth, which is 1974. So you can see these are the statistics that are now per 1,000. Bachelors means men who are unmarried, and spinsters, particularly derogatory term maybe. And my mother would talk about spinsters as being particularly women in their late 20s who were still on the shelf and not married. So you can see 7.6 for bachelors and 24 per 1,000 for women. Not figures that I expected. I expected these figures to be maybe somewhat higher. And again, you see our fascination with the United Kingdom in the first paragraph after the table, where we again are saying that we're significantly lower than England and Wales. And I'm wondering about why that might be, and particularly in terms of economic factors. To bring it up to present day, the task was to think about this from two perspectives, one from my discipline and one in terms of Ireland. So when I got married in 2012, I didn't realize that I was bang on the statistics, which was that I was in my 30s. So in Ireland now, men and women and also same-sex couples get married quite late. They get married in their late 30s, which got me to thinking about and I'd like to give recognition to Conor here, because this is his work, in a conversation about, well, what actually is the situation in Ireland? So we allow people to get married when both parties are 18 years or older, but we do have an exemption for children to get married who are 16 and 17. And that exemption, you can see what the exemption is on the screen. We don't recognise marriages of Irish citizens who are under 18 who get married elsewhere. And we don't recognise marriages where parties get married in a jurisdiction where it's legal to get married, who are not Irish citizens and who come to Ireland. Very much like there's an international movement at the moment to get states to amend their legislation to remove these exemptions. And Ireland is about to join that club. So our Domestic Violence Act in 2018 has a provision that removes that exemption, but it's not yet enacted. So in terms of what actually how many children are we talking about in terms of Ireland who get married who are Irish citizens, we're talking about 7 in 2017. So maybe this is the disappointment part. I don't have much to say about how we deal with children who are Irish. And you can see here, particularly in terms of 3 of the 7 were of the same age, and 4, there was 1 to 4 years of a difference. If you bring that up to teenage years, 18, 19, you see that there were 59 persons who were young persons under the age of 20 who got married. Then that gets you thinking about, well, how many migrant children do you have? And you would know from Helen Stalford's paper last night and her slides that Ireland has very few separated children or children seeking asylum. So as a good researcher, I rang around all the child welfare departments and said, well, what do you do in Western democratic states with very strong child protection laws and policies when a migrant child comes and says that they are married and they are 14 or 15 and their partner is older than them, an adult or significantly older? And I couldn't find any examples. They couldn't give me any answers. So that led me to think about, from my disciplinary background, so I was a social worker, I was one of the people who used to get those phone calls. So what would I do? What would I need to think about? And what would other states need to think about? So I'm thinking about whether the person is accompanied or not. I'm thinking about their citizenship. I'm thinking about whether they're pregnant or not pregnant or whether they already have a child. And I'm thinking about the age gap. And the age gap is interesting because of our legislation, our child sexual abuse legislation, because age is significant in terms of the gap between a young person and the person who is older. And to what extent that raises a question about the legal age of sexual consent, and it also raises a gap about our question in relation to informed consent. So to what extent can somebody give informed consent? And this has been a discussion in Ireland in relation even to the digital age of consent. So to what extent if somebody is entering into this a marriage contract? And I suppose, where is the evidence of the marriage? If Ireland has very strong normative rules and laws and a constitution in terms of interfering in the private family life. So if we don't recognise this as a marriage, or there's no evidence of it being as a marriage, are the rules of state intervention somewhat different? And I suppose the raising question about, is there coercion? So Auden in his introduction raised the question about trafficking and raised the question about, identified why someone would get married young. And if you look at the background in terms of the top 25 countries that have child marriage, the key themes are to do with social instability, they have to do with conflict, fragility, and natural disasters, but can be key themes. So and it raises questions about, well, what did a marriage mean to that person in that country? And in particular, the civil society groups that I spoke about talked about the significance of political, military, and socioeconomic instabilities in the countries where that marriage may have taken place. And Auden mentioned the cultural practices and norms. And I suppose the last part is, what's the narrative of what the marriage means to that child or young person? What's the story, what's the social history of what that marriage meant? So we were asked to talk about solutions. So suppose taking those themes, assessment themes together, which makes a very complicated assessment or a very complicated process, as Helen spoke about yesterday evening. So the question arises, what's the justification for state paternalism in those kind of cases? I suppose I want to suggest to you that we're not really talking about child marriage in the same way that Aries suggested we're not really talking about childhood, we're talking about childhoods. There's a very significant difference between 2 young people who are 16 who are married in another jurisdiction who come to Ireland compared to somebody who was trafficked, who was 14 and compared to somebody who was 15 and their partner is 25. So are there differences? Do we need to think about them differently? And does state paternalism, when it's exercised, different in those cases? So that raises a question about, should we have a more universalist approach, or do we allow decision makers discretion when thinking about assessing those cases? We need to think about the state's engagement in international and domestic political context. So to what extent are governments engaging with lobbying at a national and an international process, and also we need to share and develop the knowledge base on the impact of child marriage, which Auden talked about earlier. But following what Helen mentioned last night about culturally sensitive communication support and supporting those practitioners. And if you look at what's happening in Indonesia in terms of child marriage at the moment, you see the power of one. You see one feminist advocate who's been very effective in seeking to remove the exemption for child marriage in that country, as well as the significance of civil society and supranational bodies having that pressure on states to think about not only removing exemptions, but there are many countries that have no exemptions for child marriage, but allow child marriage, but they don't enforce. And you might think about certain countries in Africa, and you might think about the East, but you also need to think of the United States. There are 16,000 child marriages in the United States every year. That's a lot. Somebody is not looking at that. So I'm thinking, in conclusion, in terms of the person who is on the front line, what is it we need to do to help them to make sense of the needs and welfare of both the young people who come, who say they are married in another jurisdiction, but also if they have children with them, the needs and welfare of that additional child. Thank you very much.
And then Satang will come and do her talk.
Hi, everyone. My name is Satang, and I'm originally from the Gambia, currently a PhD student at the University of Pretoria, specifically the Center for Human Rights, but also linked to the Law Transform as a PhD scholar. So basically, my presentation is not going to specifically look at a specific country. I intend to give an overview of child marriage laws in Africa, but mostly, especially in terms of what the African Commission and the Committee on the Rights of the Child are doing in terms of regionalizing international human rights standards that relate to protection of especially the girl child from forced and early marriage. So my presentation will basically look at giving an overview of a study that we did in 10 African countries, which informed the Joint General Comment of the African Commission, as well as the African Committee on Ending Child Marriage. So I was part of both processes. I was both a researcher of one of the countries regarding the study, but also part of the drafting process for the Joint General Comment that was adopted in 2017. Just to quickly give some stats, I think the previous speaker have also said a little bit regarding statistics regarding child marriage. But basically, especially in terms of Africa, currently, according to UNICEF, there are about 39% of girls are actually married before the age of 18. And among these 18 African countries are actually part of the 20 countries with the highest rates of child marriage. And as a result of the statistics, the African Commission, so that's the report on child marriage in Africa from the study. The African Commission on Human and People's Rights actually had a resolution in 2014 that spoke about the need to conduct a study on child marriage in Africa. And as a result, both the African Committee of Experts on the Rights of the on the Rights and Welfare of the Child and the Center for Human Rights of the University of Pretoria were asked to contribute their support and expertise to the conduct of the study. And probably just basically, just to give an overview, the Committee of Experts is actually the body that oversees the implementation of the African Charter on the Rights and Welfare of the Child, which is actually drawn from the UNCRC. And the African Commission oversees the implementation of the Maputo Protocol, which is the Women's Rights Protocol, which actually draws inspiration from CEDAW. So they are the regional instruments relating both to the CEDAW as well as the CRC. And for the Maputo Protocol, which is the Women's Rights Protocol, it actually covers both the girl child as well as women, and that is why there was actually a need to do a joint study that relates to both bodies. So the study actually looks at the issues that addresses children at risk of child marriage, children in child marriages, and women who were also married before age of 18. And the idea of the study was just basically to give an overview of regarding child marriage laws, especially in terms of their compliance with international and regional human rights standards, but also in terms of what are some of the domestic laws that are actually not in compliance with these laws and how best to resolve these issues. So the study was actually conducted in 10 different African countries. Even though it's pretty small and not comprehensively covering the whole of Africa, the idea was that the countries were distributed in terms of geography, coming from the west, from the south, east, as well as also highlighting that most of these countries also basically have one of the highest statistics when it comes to child marriage. And as a result, we wanted to find out what might be the issue, especially in terms of basically in terms of the laws as well, because most of these countries have actually ratified both the CRC as well as the African Charter on the Rights and Welfare of the Child. And basically some of our key findings that are clearly discussed before is the fact that when it comes to child marriage, it is a clear manifestation that it is gender inequality and also a very religious and social norm as highlighted by the chair before, but also it is very much informed in terms of the issue about poverty and also the lack of access to education, as well as the impact it has on girls' education and sexual and reproductive health and rights and domestic violence issues. But especially regarding the legal frameworks, what we found in the 10 countries is the fact that despite their international and regional human rights obligations, their national laws were actually not in compliance with the laws. For instance, both in the Maputo Protocol and the African Charter, which draws its inspiration, as I mentioned before, from the UN level, the minimum age of marriage should be 18. But most of these countries were actually not having laws that are in line with this. But even if they did, one of the key problems in terms of African countries is the plurality of the legal system. For instance, in the Gambia, you have at least 4 different marriages. And as a result, especially in terms of customary marriage as well as Muslim marriages, they are not usually in compliance with international standards. And as a result, even if the state has an international obligation, it is not usually in conformity with the international obligations and so forth. And then also there is the lack of there is ambiguity in terms of the law, such as in the case of Malawi, but also in terms of the lack of enforcement of child marriages as well, even though some countries do actually have laws, for instance, in the Gambia, where we had a law in 2015 regarding a ban on child marriage, but in reality, it is not enforced. And one of the key shortcomings, especially with laws as well, when it comes to enforcement, is the fact that there are no remedies per se, or no, so there are no possibilities of actually taking people to court per se. Like there is the idea that, okay, child marriage is banned, but it doesn't usually come with penalties, and as a result, it doesn't usually deter people from actually going in and forcing girls, mostly girls, into child marriage. And as a result of this study, both the committee and the commission actually agreed to come up with a joint general comment on ending child marriage. This also draws inspiration from the UN level as well, which has a joint general comment or recommendation from both the CEDAW committee as well as the CRC committee. And in terms of the joint general comment, it's actually premised both on the African Charter on Human and People's Rights, but also specifically on the African Children's Charter, on the Articles 1 and 21, as well as the Maputo Protocol as well. I just wanted to quickly highlight some of the content of the Joint General Comment. I just have about a minute more. And so one of the requirements for states is that they are supposed to specify that 18 years as the minimum age for marriage. And also there are legal prohibition of harmful traditional practices, such as abduction for marriage as well, and also legislating on full and free consent to marriage, as well as ensuring verification of consent by marriage officers. I think one of the key problems we had, especially in terms of trying to verify child marriages, is the issue about registration. So usually there are no registrations when it comes to marriages, but also even with birth registration. So we have the issue of lack of birth registration for most children in Africa. And as a result, in order to verify that that particular girl or particular boy is actually below the age of 18 is usually a problem. But apart from the legal measures as well, we also had the institutional measures that talks about access to and uptake of health services, also the promotion of access to justice, as well as ensuring that there are rehabilitation and redress support for children that are already married as well. And the other measures actually deal with the interrelated cause and consequences as well, and mostly the drivers of child marriages, especially talking about poverty reduction, also ensuring that girls and children themselves are actually involved in the decision-making processes as well. There are also gaps in terms of the Joint General Comment, which is the fourth Joint General Comment at the African level, but I think it's actually a useful tool, especially for advocates and so forth. But I think, I know my time is up, just a question probably that we have in Africa, and is the issue about, okay, fine, if child marriage is prohibited, if child marriage is criminalized, then what happens to children that are already married? Are you going to take them out of the marriage? Is that in their best interest? Or are they going to stay in the marriage? And I think especially with the influx of migrants into Europe, I think this is also a debate that is currently going on in terms of what are you supposed to do with girl brides who are already married to older women? Are you going to separate a family that has probably already been traumatized? Or are you going to ensure that they're actually protected from child marriage? So basically that's it. Thank you.
And then Judith Oburn will come and have some comments on that, I think.
Morning, folks. When Ogden asked me to talk about this, I thought, good gracious me, why me? And then I thought about it. I did once write a book, and it was the first time I came to Norway, actually, to talk about that, which is social services for minority ethnic families. So I have thought about practice with minority families. And then I thought, I've got a son who is married in the eyes of Allah, but not in the eyes of the British state. So I ought to be thinking about this as well. But our issue tends I should talk about the position in the UK, England and UK, tends to be more South Asian families, although increasingly African families. So I found what you said very interesting. The question, it's very interesting. We spend a lot of time talking about what's happening in child welfare issues, and I can't recall once hearing anybody talk about this issue of children who enter the country already married, which I thought, why is that the case? And I suppose it's the case because we stop them coming, basically. So first defence against this problem is not to have them. But of course, that doesn't work because of the refugee situation and the asylum. There must be, given the figures you've got, there must be a lot of the asylum seekers across Europe who see themselves as married, even if maybe they're not declaring themselves to be married. So I think we have a lot of child brides in England who we don't talk about, know about. I think probably when they come, they live with families. they don't talk about it. If they might well be refused immigration permission as child brides if they did mention it beforehand, so why would they? So it's an issue that we really ought to be paying more attention to. What are we paying attention to? First of all, I mean, there is the issue of Islamic law and Sharia law, and how does that fit with British law. I'm no expert on that. As I say, I probably ought to be in the situation of my families. But because of my daughter-in-law's relations, I do spend a lot of time talking with the in-laws, as it were, and so it does give me pause to think about this. What does arise in our laws? Well, first of all, there is this debate about Islamic law and Sharia law, but secondly, the two areas where we are very concerned is FGM, and we don't have mandatory reporting in England. The only reason for mandatory reporting is FGM. So if professionals know that FGM is likely to happen, they have to report it, but nothing else, which is quite interesting. I have to tell you, it's been in law for about 10 years and nobody's ever used it. So that tells you something about the value or not of mandatory reporting. I'm looking at Thomas there. What the law does, the law does allow us to intervene, our police, if we know if this is happening, and our social workers. And the other one is forced marriage, and of course, children, young people, children under 18, adolescents going off for a holiday to the family in Pakistan, and oh, by the way, we'd like you to meet this man, and you are going to marry him, aren't you? So we do have legislation now which is quite strong on forced marriage. Now, some of these child brides who are in our country will have been the subject of forced marriages, obviously. So that's the legal position. The reality position is all children, whether married or not, come under our child welfare legislation. So they will be seen, the mother will be seen, if she is a mother, as a child in need. But the child bride, who we realise is in our country, will be a child in need. So officially, or may well be a child in need, may come to attention. But one of our problems is we don't have compulsory schooling. Some of you might know the famous Victoria Kalimbi case. That child got lost. Now, in theory, we have compulsory education, but we have something called education otherwise. So families can decide to not send their children to school, and we don't know who they are. So I suspect that there are quite a lot of children who are married, who we don't know about, who may well not even be going to school. And it's a big issue in finding out what is happening to the informal schools, particularly some of the Muslim schools, which are very worrying in terms of the sort of schooling they're providing. So there are all sorts of issues, and I'm whittering on really. But these are very serious issues, and we should be looking at them. And we're not looking at them as much as we should. And certainly the children who go under the radar when they come into our country are extremely worrying. The other area where this comes up, of course, is separation. So when the child bride, as will frequently happen, wishes to separate from the man she's been living with, they may often legalise the marriage. They won't tell you. She won't tell you she's married, but come 18, they'll marry, and it will be the family who will require the marriage. And the young woman probably doesn't have a lot to say about that. So, is that or is that not a forced marriage? Do we come in as child welfare agencies and courts at that point? But when those people separate, then the courts do come in, and the area where law comes into it particularly is the private law cases in the family courts, when all of this might come to light, and the judges and the CAFCAS officers particularly will become involved, and then you get the issues also of custody, one of the parents, usually the man, wanted to take the child, if there are children of the family, overseas again. So the courts do get involved. The private law courts are getting involved in separation and separation cases, because they're often not actually legally married. So that's a wander around what we are trying to do, and indeed I suspect what we're failing to do. Thank you.
Okay. A German perspective. Good? Better? Oh, good. Some numbers first. The German Institute for Human Rights did research and counted the numbers of marriages with children involved, and by July 31st, 2016, we had 1,475 children being married in Germany. 1,152 were girls and young women, and 317 were boys and young men. As Satang pointed out, there's a clear gender inequality, but 317 boys indicates that it's not just the 12-year-old married to a 40-year-old man. It's a diversity, it's a very broad and diverse picture when you look into the single situations. Okay. There was, in 2016, there was a call for protection in the Ministries of Interior and the Law and Order authorities and parties that are connected to this policies in particular, but nobody could stay away. Everybody had to take position because it was very strong in 2016. But the loudest voices were accompanied by they have to apply to our norms, and if they come to our country, they need to respect women, not so much women's rights. Respect women. And usually these are the ones you have not been encountered as the fighters for women's rights. Those were the ones standing up most strongly. Okay. So this was the situation we went into, and there was a debate on a legal reform. We had that legal reform, and the legal question is about how to deal with it. It's about nullifying or non-recognition. Nullifying means there was never a marriage. By the time they enter the country, the marriage is within Germany dealt with as if it was never existed. And non-recognition means there has to be a decision based on an assessment not to recognize with certain criteria when to recognize and when not to recognize a marriage that was two persons went into in the foreign country. Okay. So nullifying or non-recognition can be an important component to protection and support, but differentiation is needed. You can, in the country, decide, as you proposed for Africa, that no marriage should be allowed for persons under 18. That's a general prevention measure. Because as a state, if you say, well, okay, they're 17 and they love each other and they really want that, but you can never get close enough to see and look into the family if it's whether it's a forced marriage or not. So you may say, if you want to marry, it's okay, just wait another year. But because we can't tell if this is a forced marriage or not, we're not allowing marriages under the age of 18. So that's general prevention. Even though in certain cases, they're really in love and they're still 17s and they want to get away from their parents and so on. There might be different, very different reasons because why they want to marry before they are 18. But we say no. And I very strongly support that. We implemented that. The exceptions we had as an island in the law are no longer in the law. You're not allowed to marry in Germany before 18. But if young persons enter the country married, they enter with an individual reality of life. They have an experience with being married for a certain period of time, and that requires us to go into, in most of the case, an individual assessment of their best interests. That brings in the best interests principle here. And that's complicated. First, you probably need to make a distinction, a cutoff age. You say a cutoff point. Well, the age of sexual consent probably is one criteria. If the age of sexual consent is 14 in your country, as it is in ours, under 14, you might consider nullifying this marriage if they're younger. In Germany, the decision was made to move it up to 16 to nullify the marriage. This is disputable, but has to be discussed. Where is the cutoff age? And over the age of 16, it needs a recognition or non-recognition. So that's a decision has to be made. So this is the age you have to decide on. But even if it's nullified, if they're under that age, you have to, as a child protection system, how to deal with them. You won't allow them to live together overnight, but you don't need to separate them completely. They can see each other, and if they want to be with each other, and need that. So that's a very difficult decision to make. But now, if you take into account the actual situation, then it becomes complicated. As Satang pointed out, they might have been married in their country and to be protected, a man protect the girl and take her with him to the foreign country and out of the war zone. And this mission the young girl takes along. And if she feels thankfulness because he protected her all along. And now she says, no, leave him, it's not good for you. Well, that might bring her into quite some conflict and might not connect to her feelings. And if she is separated, that might mean a breakup with her family back home. That might cause a lot of problem for her. So you're not in line with my interests. Please listen to me, what my interests are. So that's more complicated. And maybe if they had a flight together and they built a sustainable marital relationship, that might be the case. You should look into that as well. And the experience of the child protection agencies was if they separated them, they went on to on flight again, and they disappeared one of the next days. So this is not the solution to protect the young persons, the young girls in particular. And lastly, the last point, there's a relationship of dependency that was built. And even if it's harmful or problematic, a legal act doesn't end that dependency. So if you just take them away, the dependency doesn't end. You need to help them get out of it. And the child is foreign, coming into a foreign country. She is feeling like a stranger. She doesn't know what is all about surrounding her. And leaving her life situation needs knowledge about the alternatives. And the alternatives needs to be recognizable, available, and felt as positive. And that's my last sentence. If we want to protect and help those young girls and boys to get out of harmful situations, protection and help requires time for building relationships of trust to help them leaving their situation if they want to, or make a decision even to stay. Okay, thank you for that reflection.
Thank you, Thomas. And now, Jana. I believe that's not yours. And this is yours.
Thank you. And I'll try and wrap this up quickly because I think I don't have too much time. I'm glad that a lot of it has been covered by Satang. I think India is not one of the 20 countries with highest numbers of child marriage, but India is the country with the highest actual numbers of minor girls married, and that's 1.5 million girls. So that puts us right on top. The 2015-16 National Family Health Survey in India showed that we had about 26.8% of girls married under 18, and we can see the differences in urban and rural areas. And causes are very similar to many of the causes raised by Satang. You get, dowry is much lesser, girls are used as household help, safety, customary practices, poverty, and of course trafficking and forced abduction. Now, I want to quickly move on to what is the law. We had, in 1929, a law called the Child Marriage Restraint Act, which was fairly weak. It initially had an age of marriage of 14 and 18 for girls and boys, which was then raised to 18 and 21. And then in 2016, it was replaced by a much stronger law called the Prohibition of Child Marriage Act. But even this law has, which is the current law, has huge gaps. The biggest gap is that child marriages, although there is an age of marriage, the child marriages are still valid. So they are only voidable. And it's a legal technicality which is actually there in many of our personal laws as well. Voidable in the sense that it is up to one of the parties, who we are saying are minor, one of the parties to actually seek annulment and to declare the child marriage to be void. And if they don't do it, it is a valid marriage. There is a big implementation problem with the law as well. Due to which this law is is really not implemented at all. We have a third angle to it. We have criminal law, and the Indian Penal Code gives an exception to marital rape. And in the exception to marital rape, the exception is that rape is recognized within marriage only where the wife is under 15 years. So this is a colonial criminal provision. So basically we had a situation where you have a law which prohibits child marriages, but you have a criminal law which gives an exception, which recognizes rape within marriages only where the wife is under 15 years. So the law is recognizing wives or girls who are minors and who are still married. So in 2017, there was a big Supreme Court decision which went to court. It was filed by an organization called Independent Thought. And the challenge to this petition challenged this exception to child marital rape as being 15 years under Section 375. And I had the chance to actually represent one of the child rights groups to intervene in this case. The Supreme Court passed a huge decision where it broadened the exception. It read or gave an interpretation that the exception should recognize rape within marriage where the wife was up to 18 years. This is actually a small introduction to possibly removing the exception to marital rape in India. But at least the reasoning the court gave was that if there has to be uniformity of laws, if we are saying that marriage of up to the age of 18 if there is an age of marriage up to 18, then we cannot recognize, we have to recognize any forced sexual intercourse under the age of 18 as marital rape. And it recognized that for the first time, that child marriage is a violation of girls' rights to life, bodily integrity, and reproductive choice. And in this decision, what was important, since we're looking at it from the international principles, is that the CRC and CEDAW did have a huge impact. We have to recognize that this is the first time the court had to rule on child marriage. It did kind of it relied heavily on the CRC and CEDAW, holding that if a child is forced by a husband into sexual intercourse against her will or without her consent, it would amount to a violation of a human right to liberty or dignity guaranteed by the Constitution and embodied in international conventions which are accepted by India, such as the CRC and CEDAW. The court relied on Article 1 and 34 of the CRC, where there's an obligation to prevent sexual abuse of minors. And not only did it rely on CRC and CEDAW, it also relied on some of the recommendations made by the committees, the CRC committees to India particularly. And there were recommendations that the PCMA should be effectively implemented, especially on the issue of personal laws. It also relied on the UN General Assembly and some of the working group kind of reports on India, which had made recommendations specifically on child marital rape as well. So I just have a few concluding thoughts. Many issues were brought up. The issue brought up by the government was that there is a huge social acceptance of child marriage. Can we criminalize it? And this was in the context of criminalizing child marital rape. And the argument raised by you and by Satang is that what happens where girls are already married? And if we criminalize child marital rape, you're basically giving the power to say that, you're putting this young girl's husband behind bars. And what do we do? And what do we do in light of the fact that there are marriages already happening? In many cases, the girls have children. What do we do? The court rejected this argument. The court rejected this argument, saying that if there are harmful social practices which have social acceptance, that cannot be justified. And we cannot take that argument that what do we do where the girls are already married? The court actually gave a statement that the PCMA overrides religious personal laws. So I think that, just looking at the African perspective, this was a big challenge in India because we had high courts giving different, judgments. We had high courts saying, Muslim personal law, allows marriage at the age of puberty. Hindu law is also very, very vague, and it does not, make minor marriages illegal. But the Supreme Court gave a statement that it would override all religious personal laws. The state had a big argument that what about the institution of marriage? This would, criminalizing child marital rape would ruin the institution of marriage, especially, again, bringing up the argument that girls are married, they have children, and are we going to put them on the streets? The court, again, rejected that argument as well. And it rejected it with the justification of constitutional fundamental rights, that if we have to protect the right to equality, life, health, bodily integrity, and reproductive choice, we have to ensure that child marriage is cannot be allowed to continue, and criminal law has to match the civil law prohibiting child marriage. And it relied on international conventions and recommendations as well. Of course, there are challenges in implementation. We still don't have compulsory marriage registration laws. So those hurdles are there. And of course, implementation of the law is a big hurdle, but I feel we've made important gains. Thank you.
Hallo?
Bare minst har musik funker. Right, thank you. Thank you all. I've been told by the powers that be, the infrastructures, that we do not have time for questions. Sorry. So let's all give them a round of applause once more.